All rise. Vous vous levez. Please be seated. Veuillez vous asseoir.
Thank you very much. Welcome back, everyone. Mr. Migai, you are on your feet, I believe, before the luncheon break. And I believe we were discussing the issue of to what extent the Rome Statute forms part of the law of Kenya. Yes. Now, before we proceed, there is a matter of procedure I thought I should bring to your attention. I'm sure you and I have made the work of court reporters very difficult because we've been talking at more or less crossing the wire on the microphone, and it makes the work difficult. I realize that when you're in full flow, it's difficult to stop, but I have right of way, you see, not because of the formalities of the courtroom, but because you have to persuade the chamber. So if there are some questions that we have, these are questions that are troubling us that we'd like you to answer. And one of them is the implication of Section 108 of the ICA. And I asked that in the context of whether or not, I mean, this is a discussion we picked up before lunch, whether or not the ICA is exhaustive in the types of assistance that it indicates that may be given by Kenya to the ICC. And it takes us to Section 108. And Section 108 comes after a listing of, or heading of, all other types of assistance. That the court may request, and ends up with the provision in sub 1 where the ICC requests any other type of assistance. Under paragraph 1L. And paragraph 1, under paragraph 1L of Article 93 of the Rome Statute. So here we see paragraph 1L coming in of Article 93. It comes in after paragraph, is that 1E? One that talked about voluntary assistance, is it? It says any other type of assistance. Does it not tell us that assistance beyond voluntary attendance of a witness may be requested by the court.
My own reading of that, Mr. President, sir, would be 108 is trying to provide a domestic framework for the implementation of the obligations under Article 93, 1L. A very narrow, very, very narrow. And this is what we called earlier in the morning the residual jurisdiction. The draftsman of the treaty spends a lot of time enumerating what kind of cooperation would be required. And at the end of it, L is a catch-all, and it is intended, in our view, to ensure that these categories of cooperation are not exhausted. We do not believe that it is intended, where there is a specific provision, to expand that specific provision. And that's why it says, I think, 1081 says, 1081B, the Attorney General shall give authority, B, if he is satisfied that the assistance sought is in accordance with Kenyan law. And therefore, irrespective of any assistance that may be sought by any other person, the Attorney General must be satisfied that it's in accordance with Kenyan law. Indeed, if I were the prosecutor, I would not invoke this sort of provision, because it actually limits more than expands. It then creates a bottleneck where the Attorney General, without reference to any other body or authority, is the judge of whether the request has complied with Kenyan law. If I were the prosecutor, I would perhaps stay with a straight and narrow, which is to say, facilitating the voluntary appearance of persons as witnesses or experts before the court. That one is clear, it is unambiguous. The Attorney General doesn't have to satisfy himself anything if it is clear that the witness has volunteered to testify.
Yeah, but yes, we know that voluntary assistance, voluntary attendance, it seems from the prosecutor's written material is out of the question, because the witnesses have said they are not coming anymore. So they will not be requesting voluntary attendance from someone who does not want to come anymore. So they now have to find a way to bring the witness if they feel that the witness's evidence is material. And then Mr. Khan raised an important question which the prosecution would have to address in their reply on the matter of why do we want to do this if the witnesses had already indicated that they had recanted their story. That's a separate matter. But here we see a listing of assistance or instances of assistance, including the section 87 you mentioned, and then all the way through 90 through 100, and then 108 talks about any other assistance.
Yes.
So he would have already, 108 would have already taken into account, does it not, Article 87, sorry, Section 87 I mean,
yeah,
that had been invoked repeatedly by both yourself and by Ms. Bosman, when he says any other kind of assistance.
If they let us assume, Mr. President, that we were exchanging communication with the prosecutor, and he wrote to me and said, I would want assistance under Section 108 of the ICA to have the following witnesses appear in Nairobi at a given forum in order for us to take testimony from them? My simple and clear answer would be Section 108 does not and was never intended to cater for the request that you are making. I believe that you invoke Section 118 in order to avoid the very clear legal requirements of 87, 88, 89, and 90. Please satisfy those requirements, and we would be more than happy to assist you. That would be my answer.
Is Section 108 not consistent with the theme we picked up in Section 20 and Section 23? Remember, Section 20 is the section that says nothing in that section limited the types of requests that the ICC may make, and nothing in that section would prevent the rendering of assistance to the ICC as they may request if it was not prohibited by Kenyan law. See that 20?
I do, sir.
And then 23 talks about, again, what may be done if there is a procedure in place. Follow that procedure. But if there is no procedure in place, make your best efforts to comply with the request. And then here we see the same theme picked up in 108. After listing all kinds of specific assistance, provision says any other assistance may be requested. See the trajectory that I'm getting at.
I think I have understood the point of departure. And maybe I should make two clear points. Point number one. We lawyers speak of the letter and the spirit of a statute. In my view, good lawyers start with the letter of the statute. Where the letter of the statute speaks for itself, you do not have to harvest any spirit of the statute. In this case, it is our submission that the clarity of the black letter law is such that we have no reason to depart from it to investigate the penumbra, as you recall Professor Hart taught, the penumbra of the rule, because the rule is so clear. That is one doctrinal issue, and I hope we have laid it down. Number two, I think that it is also important to make the point that where a rule of law is specific, very specific and clear, the clarity of its specificity cannot be taken away by the generality of another rule. And let me give you an example, Mr. President. In domestic law, in procedural statutes, there will always be a general catch-all that says, notwithstanding everything set about us in this statute, nothing would diminish the power of the court to do justice, substantive justice. A lawyer who comes to court and says, I am looking at the Criminal Procedure Code or the Civil Procedure Code, but I find no basis for my application in law, but I want the court to use its general powers to do justice. In my own view, that would not be a good lawyer. What law can do is set by Parliament. Lawyers should not be creative to find within law that which the legislature has not provided for. I want to repeat, therefore, the argument, Mr. Chairman, sir. The Rome Statute was debated at great length, and I have been presumptuous enough to bring this article by this very distinguished professor, who I would like to believe that, Mr. Chairman, you are familiar with, Mr. Joran Slater, Professor of International Law at the University of Amsterdam. He makes this argument so eloquently that these issues were debated at great length, and then they were abandoned for lack of consensus. For you, Your Honor, Mr. President, and this court, for you to write into this statute what was rejected at the Assembly of State Parties would do a great disservice to this court.
It would be, I think it would help us more if we had provisioned in the statute itself, actually, that says that the court may not do X.
Aha.
It's better, it helps everyone better than an academic article that was written before the court actually confronted a question to deal with it. So if you have any provision in the statute, or even the laws of Kenya, that's my trouble here, I'm trying to constantly come at. The provision that clearly says the court may not do X, then please bring it to us so we can read it, either in the Rome Statute or in the ICA. That would be very greatly helpful to us. We need not go to the extent of the maxim that whatever the law does not forbid, it allows. There's a maxim like that, as you can remember, but we need not go that far. Right now, if we can limit ourselves to a clear, what you call plain letter of the law, that says this shall not be done by the court. And this is important because one interesting position we found ourselves with in this court, and of course it makes, people may make what think of it, is we find that when it suits one side, they tell us, you have all the discretion in the world to do something, but then you'd be surprised the next day when it doesn't suit them on something else. And no, you don't have the power to do anything. So here we are. You remember the excusal debate we had? That was part of it. So here, if we have a provision that clearly says, no, you don't have the power to order a witness to come to court or make a request of a certain kind to a state party, that will help us more than academic articles written before the chamber has actually had a live case and had debate from so many lawyers on this question, on the matter.
I want to say this, Mr. President. We must warn ourselves of the danger of creating a false dichotomy. What we write in law on the whole is what can be done. And that is why 93 is a very exhaustive provision in the treaty. It says the state parties shall cooperate in this way: identify, take evidence, question, serve documents, facilitate.
And it ends with the L.
And ends with the L.
L.
It is very unusual, in my experience, for a statute to dedicate itself to what cannot be done. Because the limit of what cannot be done, the permutations are they are unimaginable at any given time. We in Kenya did not write the International Crimes Act to say what will not be done by the court or by somebody else. We wrote it to say what will be done. So if you ask me, as you have, show me where it says you can't do it, I say I can't show you because that wasn't the purpose of our statute. If you ask me, show me where it says what you can do, that's what I've shown you. 86, 87, 88, 89, 90.
And 108.
Yes. And yeah, very good, sir, that you brought me to 108. Let's look at its heading. Other types of assistance. The draftsman could not have been clearer. The draftsman is saying, I have set out extensively specific instances of the obligation of the state, and goes on and on and on and on and on, and then says, if I have forgotten something, other types of assistance. Let me then suggest this to you with tremendous respect, Mr. President. The obligation that you now impose on me is an obligation that lies squarely in the hands of the applicant. The applicant must convince you that they have exhausted the very clear, specific, and detailed statutory procedure and therefore have become entitled to a fuzzier, secondary, indeterminate, controversial procedure. That's their duty, not mine. My duty is a simple one, which is to say, I have shown you everything that the statute demands me to do. I cannot show you things it doesn't demand me to do because it is not written to exclude. It is written to itemize. So, my simple answer is this. The government of the Republic of Kenya cannot and does not believe it is under an obligation to demonstrate that there is an impediment to the execution of a secondary request where the primary one in the first place has not been made and has not been demonstrated to be deliverable under the specific law. Let me put it differently. 108 cannot be a refuge. It cannot be a refuge for a prosecutor who is manifestly unable to bring his case on a long, clear, well set out provisions of the law. So, even if this court were desirous of doing justice, of being fair, of doing equity, of doing all the great things we like to see done, they must be done in accordance with the law. And if the law, as it is our submission, is very clear, it says, do this, do that, do that, do that. And the prosecutor says, I have been unable to do what the law says. Please find for me somewhere a spirit, some woolly, some fuzzy, find me refuge there. It would be a very unhappy day. And I can tell you this, my Lord Chairman, Mr. President, I can tell you this with your permission. It would come to haunt this court. It would open a Pandora's box that would never shut. Because the treaty...
It isn't woolly because 93L says what it says. It does not woolly. It says any other assistance apart from those listed already from A to K may be requested. So it isn't woolly as if there is no legal basis for it.
It is woolly where it says in L, any other assistant which is not prohibited by the law of the requested state. Now, what is not prohibited in the law of the requesting state is not something to be determined by the prosecutor. It is to be determined by the receiving state. We in Kenya are masters of our own jurisprudence. What does our law say? What does our law compel us to do? We, with tremendous respect, submit to this court that we are the judges of that.
But it's not that simple, though, is it? And the reason I say so, if you look at 93(1)L,
yes,
it is in fact an unusual provision in international law in the sense that it is telling a state party, you may rely on your local law to refuse to perform what may be characterized as an international obligation. Now, that is what makes it unusual. The usual thing in international law is that a state may not rely on a local or domestic law to defeat what may be an international obligation. You know that.
Yes.
So here we have the generosity of 93(1)L saying any other assistance that is not prohibited by the law. Why does that become something that may not be requested? It will be a bad day, and you do not encourage the court to go through that route.
Absolutely.
Yes. Why?
Let me say this. From where I sit, my interpretation of what is not prohibited by domestic law is this. As the Attorney General of the Republic of Kenya, invited to act in a manner that calls me potentially to compromise the rights of a citizen of the Republic of Kenya, then I say this. If the statute doesn't expressly ask me to do that, it prohibits me from doing that.
Now, the right of a citizen of Kenya, for you to make that argument, you need to convince us that the laws of Kenya would not permit a citizen to be compelled to appear in any court. We begin with that.
Yes.
The laws of Kenya do not permit compellability of any witness to appear even before the Kenyan courts. Then we're getting somewhere.
Indeed.
Right. Short of that, I mean, once you've overcome that, then the next obstacle is where the law of Kenya says that a citizen may not be compelled to appear before the ICC. Do we have any or both?
2 points there, Mr. President. Number one, the entire constitutional law jurisprudence of Kenya is founded on a very simple principle. Where the coercive powers of the state may be used against a subject, a citizen of Kenya, it must be on the basis of a clear law, clearly set out by the legislature, empowering that organ or that officer of the state to do so. Under Kenyan law, we cannot compromise, and whenever you take the liberty of any person, even so that he may testify in the tribunal, any tribunal, you have taken his liberty away from him. You have taken the right for him to be where he would have been otherwise. It cannot be by inference that we shall do that.
But it's not by inference, is it? When Section 4 says that the Rome Statute, in the listed part, including Part 6 of the Rome Statute, shall have the force of law in Kenya.
It does.
So that is the force of law in Kenya.
Yes.
If we now plug into that,
Yes.
Part 6, in its elements that includes Article 64, 6b, which you have, at least to some extent, and I believe Mr. Ruto's counsel have gone perhaps further, I don't know,
No problem.
to agree that it can involve making an order, a compulsive order on a witness in certain circumstances.
First, I think that gives me an opportunity to raise another doctrinal question, which is, there seems to be an assumption that the Rome Statute and the International Crimes Act have a special place in the hierarchy of Kenyan law. Let me discourage that notion, because they do not. Under the constitutional law of Kenya, all statutes, all of them, lie below the Constitution of the Sovereign Republic of Kenya. And no statute, no matter this very important statute that we ourselves joined voluntarily, or indeed any other, including the Universal Declaration of Human Rights, including the UN Charter, nothing overrides the Constitution of the Republic of Kenya.
And I think that is recognized in 93(1)L, isn't it?
Yeah.
That is already,
that's right.
It's implicit
yes.
in there. So the question then becomes, what does the Constitution of Kenya then say, which defeats the prospect of the request to be made to the government of Kenya?
That's right. Let me read for you what the Constitution says in the Supremacy clause, which is Article 2.6. Any treaty or convention ratified by Kenya shall form part of the law of Kenya under this Constitution. What does that mean? First, under this Constitution, meaning the Bill of Rights of the Republic of Kenya, securing, and I am about to read that for you in a moment, if I should go there, all the rights secured for the individual in Chapter 4, Part 2 of the Constitution, the right to life, equality and freedom, human dignity, privacy, freedom of expression, freedom of association, freedom of political rights, and so on and so forth, fair administrative hearing, access to justice. These are the fundamental juridical norms that govern the Republic of Kenya. If there be a law, or any treaty, or any convention, or any judgment of any tribunal that compromises those principles, the government of the Republic of Kenya would be invited, therefore, to determine whether it will obey the Constitution or it will obey some other.
But you've not been put in that position at all.
I would hope we never get there.
No. You have not been put in that position because Article 93(1)L does not put you in that position. It says any other assistance that is not prohibited by the law of Kenya. So it is now for you to say, yes, the assistance that is being requested or that is being contemplated is forbidden by the Constitution of Kenya in these terms, and then you read out the specific provision of the Kenyan Constitution that says, no, this cannot happen. That's why we invited you to come and help us.
Good. First, let me say this, and I think I'll be repeating myself, but it probably bears repeating. In my own understanding of the law, where the government of the Republic of Kenya enacts a law through its parliament or through the conclusion of a treaty, and where that law creates very clear circumstances in which the fundamental constitutional rights of a citizen of the Republic of Kenya may be abrogated or compromised, there can be no other basis of compromising those rights absent a clear empowerment of an officer or an institution. So to the question you've put to me several times, which is this: show me where it says you can't do it. My answer is, In our jurisprudence, we do not write law to exclude, we write law to include.
That
so
also,
this statute tells me,
yes,
if I
yes,
may,
you said that. Do I then take it to mean that there is no provision in the Constitution of Kenya that excludes that? I mean, that's a simple question.
That excludes what?
Excludes the type of request that is contemplated in the prosecutor's application.
If you're asking me, Mr. President, does the Constitution of Kenya address the question of whether a tribunal, an international tribunal, having made a request about a witness to be brought to Kenya, to have his testimony taken, can or cannot be compelled? The answer is no. I do not know of any country in the world that would write such a rule in the Constitution. But let me finish this, sir, if I may. I don't even know of any country in the world, and I would challenge my more distinguished and learned colleagues here, to tell me by their own research and endeavors, any country in the world that has domesticated the Rome Statute, yes, and that has then set up a category of a section that says the following acts are not prohibited and the state is at liberty to enforce them. There is no style of drafting of that nature in the world. That is why the discretion in 108 is my discretion.
All right.
Yes.
Now, we've established that the Constitution of Kenya doesn't exclude.
And I don't know of any in the world that does.
But what we do know is what you've read out now, the Constitution saying treaties ratified shall form part of the law of Kenya. We also know that Section 4 of the ICA says certain parts of the Rome Statute shall form part of the law of Kenya. When we have that in place, and we have a provision like Article 64(6)(b), which says the chamber may require attendance of a witness, on what basis do we then say that that sort of request is not accommodated by the law of Kenya in the absence of clearly excluding language? That's my dilemma.
Right. I think we have misunderstood each other, because I thought the question you were asking me is, does the Constitution of Kenya speak in specific language to the question of what is to happen in an instance such as we confront, where an application is made for evidence to be taken from a witness? And my answer was, the Constitution of Kenya is not a procedural statute.
That wasn't my question.
So now let me answer your question. The Constitution of Kenya does. It does create fundamental norms that preclude the exercise of arbitrary power by government officials. And the Attorney General is a government official. The Attorney General of Kenya cannot exercise arbitrary power against a citizen of Kenya, then say, I have no specific law that allows me to hold you incommunicado. However, there is no specific law prohibiting me from doing so if the request is from the ICC. This is what the Constitution of Kenya says, Mr. President, sir. Freedom and security of the person. Every person has the right of freedom and security of his person, including the right not, A, that's 29, Article 29A, to be deprived deprived of freedom arbitrarily or without just cause.
Mr. Mugai, you see, we have to move on.
Yes.
It looks like keep looping back into notions that extend the debate. You're now invoking arbitrary action. I don't know how we can say arbitrary action when there's provision that we've been reviewing all along what they mean, and whether ICC is part of the ICC statute is part of the laws of Kenya.
Absolutely.
So,
Subject to the Constitution.
so the point about arbitrary doesn't come in. But let's move on. One point you make in your written submissions is that whatever think you made that point
Yes.
in the context of the reading of the word require, its meaning within Article 64, 6b, and you say we need to go back to Article 31 of the Vienna Convention on the law of treaties.
Yes.
You remember that?
Yes.
And naturally, that also goes, I take it, for any other provision in the statute, including what to make of Article 93. So we go to the Vienna Convention on the law of treaties, Article 31 of it.
Yes.
Right. And the provision is, quote, which you set out in your written matter.
Indeed.
A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in that context and in the light of its object and purpose. Unquote.
Absolutely.
You make that point.
Yes.
So there we see four notions, I believe, that are implicated in the provision. One, the notion of good faith. Right. What does that mean in the context of a criminal trial? The search for the truth. How does that throw light on the interpretation of the word require as the word is used in Article 64, 6b?
Let me come to, may I? First, I welcome the opportunity to discuss what the Vienna Convention on the Law of Treaties means for these proceedings. We are a treaty body. This chamber, this court, is created by a treaty. This treaty is negotiated by independent sovereign states. In the course of that negotiation, those sovereign states consider various possibilities, advised by eminent jurists, like some of those in this court today. If they make, or I cannot think of a more eminent person than my friend the prosecutor, and so I mean that as well. But what I meant, Mr. President, is that Article 31 of the Vienna Convention is telling us a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its objects and purposes. I would imagine that even the most creative jurist in this courthouse admits that this treaty speaks in the clearest possible language about the voluntariness of the testimony of witnesses. There's no doubt about that.
No, they don't agree with it, and that's a question to be determined still. So let's not assume it.
Well, I thought that was considered, that as a fundamental principle of the treaty, it is anticipated that witness will appear voluntarily. Shall we call it the general rule, then grant them the exception they are trying to create now?
The general rule, indeed.
The general rule is that witness will appear voluntarily. That is the spirit of the Vienna Convention. We must give the treaty its clear and ordinary and unambiguous meaning and interpretation.
We're beyond that. We're beyond that. We're beyond that. We're now in the stage where there is no question of voluntary appearance anymore. The question is, can a witness be compelled? That is the question. So let's lead ourselves to that
and the answer,
and see what the concept of good faith invoked in not only Article 31.1, but also Article 26 of the Vienna Convention on the Law of Treaties. Say, what does it mean in the context of the search for the truth, where the witness refuses to voluntarily appear in the search for the truth? Remember in the beginning I cited you and your eminent credentials as a chief law officer, and if this trial were happening in a national jurisdiction, a witness says, I do not want to come in the search for the truth in a criminal inquiry. What should be done in the context of a provision that says trial chamber may require attendance of a witness in the courtroom?
Let me first say that in the context of the Vienna Convention in Article 31, I would like to remind the honorable judges, the Vienna Convention is speaking to the obligation of states. It is speaking to the obligation of states, and my Latin is not very good, but I believe it is Pacta sunt servanda.
Pacta sunt servanda.
Well,
yes.
Yeah, you are, my lord, you are a more learned man than myself.
No, I'm not. Sure.
But I am obliged by the correction. It is you are bound by your undertaking, by your commitment. It is the state. We are in a very difficult situation where we are talking not about the obligation of the Kenya government per se, but the rights of a citizen of the Republic of Kenya that are independent of the state and to a very large constitutional extent cannot be compromised by the state. If the government of the Republic of Kenya went and negotiated a treaty that said, we will never require any extradition requirements, any country in the world can write us a letter and say, we require Mr. Odede, that treaty would not be worth the piece of paper it is written on. Why? Because the rights of the citizen of the Republic of Kenya are so fundamental that they would trump in a contestation the clearly unconstitutional treaty. And in international law, as all the jurists here know, it is the responsibility is a responsibility of the government. It cannot be the responsibility of the citizen. We cannot.
In a domestic criminal trial, let's say there's a robbery or a murder, and a witness that the DPP or the prosecutor wants to call, insistent calling, says, sorry, prosecutor, I'm not coming to court. Does the Constitution or the Bill of Rights authorize that witness to stay away and not be compelled to appear?
You have invited me, Mr. President, to compare oranges and mangoes. A prosecution under Kenya's domestic law in enforcement of Kenyan law is a completely different thing. And I know in the morning you alluded to the International Court, Criminal Court being a Kenyan court. That is metaphorical. It is not juridical. Kenyan courts are set out in the Constitution. The Constitution says clearly the Supreme Court, the Court of Appeal, the High Court, and the subordinate courts. There is no reference to the ICC
but
or
it does
indeed
say,
the ICJ.
But the Constitution says that every other treaty that has been ratified is part of the law of Kenya.
Yes.
So the Constitution need not mention the ICC, does it? If it says any other treaty ratified shall be part of the law, and the Rome Statute has been ratified.
Yes, yes.
And the Rome Statute is the enabling body for the ICC.
Well, the simple and direct answer to you is that that does not make the ICC a Kenyan court. I doubt that judges of this court would like to be referred to as Kenyan judges.
I don't mind. Speaking for myself, I wouldn't mind that at all, but go on.
This is a court that is recognized by the law of the Republic of Kenya as a court that has a limited jurisdiction. May I add, a very limited jurisdiction in its application to the Kenyan state and the Kenyan people. And that application is confined to the trial of war crimes and crimes against humanity. Now, if you've ever looked at our penal code, we have more than 300, 400 criminal offenses. So to call this court a Kenyan court for purposes of that would be inaccurate. It's a Kenyan court in a metaphorical sense, the way the East African Court is, the way the African Court of Justice is, the way the International Court of Justice is a court that Kenya ascribes to by treaty. So let me come back to the last point and state this. The Constitution, the application of the International Crimes Act in fulfillment of Kenya's international treaty obligation as contained in the Vienna Convention requires me to keep asking myself what was the context and object and purpose of the treaty. And may I tell you, my Lord Chairman, Mr. President, what my answer is? The purpose of the treaty was to create a fair, independent, impartial tribunal that would effect justice in matters of international criminal law as defined. Further, that jurisdiction, being a limited jurisdiction, the statute is permissive. The statute was intended to show under what circumstances you can do something. For the Attorney General or the DPP or the Minister of the Interior to arrogate themselves extra penumbra powers by saying, I have looked at the International Crimes Act. Nothing says I cannot send you to The Hague, at least until Monday. I know they will come back. The prosecutor told me he will send you back. And the victim, and this is a real victim then, and the victim asks me, why would you do that? And I said to him, show me something that says I can't do it. This is what law, this is why the Magna Carta was written, that all these plenary powers of kings and unaccountable individuals should be subordinated to law. If this court was invited to find that we have opened a new era in which the Attorney General or the DPP or a minister says, anything not prohibited in this law is permitted to me. And right now, I think I would like to smack your face. Show me something that says I can't do it. It would be preposterous.
Hold on. Of course you can. It's up to you if you want to say that. That's one answer you can give, and no one. But then it is another law officer, chief law officer, may not. So may she not take the view or reply to the witness that we have a constitution that says the Rome Statute is part of the laws of Kenya. And we have Section 4 of the ICA that says the Rome Statute in certain sections is part of the law of Kenya. And within that is a provision that says the chamber may require the attendance of witnesses, and that provision is in Article 64(4)(b). It is on that basis that we say power is not arbitrary. It is part of the law of Kenya to the extent that the Rome Statute is part of the law of Kenya. Is that not an answer that can be given by another law officer who chooses not to make the argument that whatever the law does not prohibit, it allows?
It is not usual in a forum of this nature for counsel to ask a question, but I probably would ask, what is this that is not prohibited?
That which Section 20 and Section 24 of the ICA and Section 108 of the ICA say, which are any other requests for assistance that have not been specifically itemized, may be made. And that might include a request for compelling a witness to attend.
It would not. And I want to repeat myself and make myself, I would hope, absolutely clear. This statute commences by itemizing, and you were quite right when you drew our attention to Section 20. It itemizes what it intends to legislate about. Then the draftsman spends a lot of time detailing, if you want a witness to appear, look at 80. If you want to serve a document, look at 86. If you want a witness to appear, look at 87. If you want assurances, look at 88, and so on and so forth. The draftsman has such clarity. And what I have been saying, which probably bears repeating, is that Section 108 was not intended to reopen the express. The draftsman is saying, if you want a witness to appear, I have discussed that exhaustively in 86. There can be no legitimate reading of the statute that would make other types of assistance, other types, meaning you have already exhausted assistance. What assistance is? You have now come to create a general provision just in case you have forgotten something else. So an argument that says, can I not come under 108 to find some authority to summon witnesses who do not wish to be summoned? My simple answer is, how can you seriously want to say that? Did you not see Section 86? Or did you not see Section 87? Bring yourself within the ambit of 87. Because what you are trying to say then to the court in that situation, you would be saying, the truth is that I know that there is a very clear provision of Kenyan law. I know that. I also know that I am unable to abide by it. I am unable to. Therefore, please find something else, somewhere for me to hook my wagon. That is bad jurisprudence. I do not want to use a stronger word that would go to impeaching motive, but it wouldn't lie in the mouth of the prosecutor, let me leave it at that and just say
while
this.
you leave it, let's move on. We still need to exhaust what's Article 31.1 of the Vienna Convention says, and you taken us to the concept of context and purpose, and you've defined context and purpose in terms of what the ICC was meant to do, the statute.
Yeah.
Is it the case or not that the preamble to the statute is perhaps the most compendious expression of the purpose of the statute? Objects and purpose.
Yes.
Of the statute. You agree? So we look at the preamble now, if we may.
Yes.
First 5 paragraphs. First paragraph, conscious that, interpreters can turn to the French version, of course. Conscious that all peoples are united by common bonds. Their cultures pieced together in a shared heritage, and concerned that this delicate mosaic may be shattered at any time. Mindful that during this century, millions of children, women, and men have been victims of unimaginable atrocities that deeply shock the conscience of humanity. Recognizing that grave crimes threaten the peace, security, and well-being of the world, affirming that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. Determined to put an end to impunity for the perpetrators of these crimes, and thus to contribute to the prevention of such crimes. Let's stop there.
Yes.
These are lofty aims, are they not?
Yeah.
Object and purpose of the Rome Statute. How do we begin to hope to achieve these ends if people who may shed light on the truth, on the inquiry rather, in the search for the truth, say, no, we don't want to come, and then we say, that's it, that's the end of it? How do you begin to hope to end impunity?
My Lord President, Mr. Chairman, the poetry of the statute is very important. It is intended to remind us of the commitments that we have made as a civilized humanity. I'm sure when you find the time in your deliberations, you will read the preamble of the Constitution, of which I am part draftsman. It contains the same exact poetry, which is fundamental, because it is intended to remind us that the things that have gone wrong in our various experiences should never be repeated. But nothing in the poetry that I wrote in the Constitution of Kenya affects the way I shall construe the right of a prisoner in a Kenyan jail. I am mandated in very clear terms to act in accordance with the Prisons Act of the Republic of Kenya. And where it says I will accord the prisoner 6 hours of sunshine and I will give him a good diet, I will not be able to answer him by saying, show me where it says you need protein once a week. What we are saying, Mr. President, is that the lofty ideals of the treaty are conceded. The work that this court is doing, if we thought less of it, we wouldn't be here. We think highly of what this court is doing in its search for justice. We are only asking this court to confine itself to law. And we are warning, sorry, that's a strong word, we are cautioning that should this court allow itself to be seduced down the road of reading more powers for itself, arrogate more powers for itself, two things will follow as night follows day. The number of state parties willing to join this court with an indeterminate treaty whose meaning is not known by anybody, whose meaning is created by the court in an experimental way from case to case. I don't know of a state that has not signed on the treaty that would sign on that basis. Say, what are we signing on? And the lawyer advising the government will say, we are not quite sure because the court creates its jurisprudence as it goes along. Shall we be required to surrender our soldiers who have fought in a neighboring country for an act of war? We don't know. It is unclear from the statute, but the court probably would want to exercise that extra power as well. We would strongly discourage, as a state party, that the court should go down this road of adventure.
Mr. Mugai, moving on, there's another line of question that I have, but before I do that, in his submissions, Mr. Stewart said that there is an injunction that prevents any judge in Kenya from acting as, I use the expression before, rogatory commissioner, you know what I mean, the judge that takes evidence in Kenya from the ICC. Is that the case?
There is an inaccuracy there because that was a specific proceeding. Those were specific proceedings and they related to specific individuals in a specific context. I think the most important thing to remember there is that these were proceedings before these cases were commenced. So they were in the nature of investigations. There was not a prosecution. And therefore there is a big difference.
Oh, right. So then what you're saying is that Article 93, 1, is it B? I think it is, that contemplates taking of evidence under oath. It's still possible. Is that the case?
Sorry, I missed that question. If you could be as kind as to repeat it.
I'm asking you whether it is the case that the taking of evidence under oath pursuant to Article 93, 1B of the Rome Statute is still a possibility. Is that what you're saying? That there is no impediment to that kind of assistance being rendered. Is that the case?
Subject to the Constitution and the law, which is what we've been debating. Subject to the Constitution and the law. If, as I have demonstrated, that this can be done subject to compliance with the International Crimes Act, the answer is yes, subject to compliance.
Let's do this. Could you kindly, 1 second. So you don't it may not be that I did not want to put you in a difficult position now of making commitments and answering questions on that point. Could you kindly, could 7 days be enough time for you to write back further submissions to the court on that specific question, whether or not there is an impediment, a legal impediment within Kenya to execute requests pursuant to Article 93 1B of the Rome Statute. When I say legal impediment, that includes the claim made earlier that there is an injunction that forbids it, and to any other law, the Constitution or any other law in Kenya that says this may not be done. Can you, in 7 days, write back to the chamber on that?
That would be very difficult because, Mr. President, sir, Article 96 is very clear. It is Article 96 that makes it possible for us to understand the nature of the request. And Article 96 says this: the contents of a request or other form of assistance under Article 93. A request and other forms referred shall be made in written, and so on and so forth. The request shall set out the following. So the hypothetical is very difficult for us to respond to unless there was a specific that is set out in 96.
No. 96 is about other forms of assistance. But here 93 specifies Article 93 1B.
No, sir, I beg to differ. 96 says clearly the contents of the request of other forms of assistance under Article 93 in its generality.
93 1L.
The whole of it.
1L.
The whole of 93.
93 1L is the one that speaks of other forms of assistance, isn't it? So
no, sir. Article 96 provides a procedure for all applications under 93.
Anyway, we need not belabor the point. I was wondering whether it might be more efficient for you to write back and say...
Yes, I can write back and repeat this.
You don't need to read. That's all you're telling us, then that's the extent of it. The question would have been whether...
If
1 second, please. The question would have been whether the laws of Kenya, either in terms of an order of a court, or specific provision of the Constitution or other law, would oppose an impediment to taking commission evidence under 93 1B. So if you're not in a position to do that, then we'll leave that.
The difficulty, Mr. President, sir, is that actually the question you have posed has created the matter, has abstracted the matter more, because the prosecution's request is very concrete, and it is this: we want you to take evidence from persons who used to cooperate with us, who have now refused to cooperate with us, who have said they will never cooperate with us again. So that is very, very, very narrow and very, very specific. If you asked me to elaborate on our response as to whether in those who have now refused law, because in Kenya we ask ourselves, is there a basis for doing this? And where there is no basis, we will not act in a manner that is inconsistent with the law. If you're asking me, Lord Chairman, Mr. President, if you're asking me to respond to that narrow question, that would the Kenya government have a difficulty executing a request that said, go and find these people? Remember, Mr. Chairman, sir, I don't know these people. but I assume that can be overcome if the prosecution allowed me to know. If the question was, would there be a difficulty on the part of the Kenya government finding these people, putting them in a chamber, compelling them, meaning finding a law in Kenya that allows me either to send them to jail until they give the statement, or to fine them, or to take their assets, or to some other penal process that compels them to, I would be happy to respond to that question.
All right, it's simple, Mr. Mugai. See, the reason why Article 93, 1B, enters the picture is this. Article 93, 1B is a specific provision in the Rome Statute. It is not a matter of Article 93, 1L, that is a catch-all. Article 93, 1B, in its own standing, enjoys the same separate, distinct standing as Article 93, 1E, that you like very much. So if 93, 1B says evidence may be taken by a Kenyan judge, remember, the prosecutor had said they would like the chamber to either do this, implement their request by way of a video conference with a witness in Kenya, or the chamber goes to Kenya to conduct proceedings and receive the testimony of these people. And you are saying, your response is, that cannot be done. It doesn't matter whether the court comes to Kenya to sit, or the court is sitting in The Hague, that the Kenyan government, your position is that the witness may not be compelled to attend. Now, that was your position. And here we have 93, 1B that specifically says it is a duty upon the state as part of cooperation to receive requests about taking evidence. And the ICA recognizes that, I believe. Not I believe, because if you look at the rules, the ICA rules, if you look at the ICA rules, the rules on the ICA, from Rule 4, specifically Rule 4 and Rule 8, provide rules for this sort of commission evidence to be taken in Kenya. It is part of the ICA. If that can be done by a Kenyan court sitting in Kenya, why would it be difficult for the ICC sitting in Kenya to not be able to compel a witness to testify when a witness can be compelled to attend a rogatory commission conducted by a Kenyan judge? It is there that I want to find a difference. We are trying to figure out what good faith means in the context of the Vienna Convention, the law of treaties, in this matter. Why the difference?
I am not sure that it is considered by us that there is, that if in Kenya we constituted a judicial panel and gazetted it, or the Chief Justice undertook whatever measure, that a Kenyan court would compel the witness on behalf of the ICC to be present in the Kenyan court. It would not.
All right, let's not speak hypothetically. I'll read the text in question. Rule 4, do you have it, the ICA rules? Rule 4, and I'll quote, the International Criminal Court may make a request.
Hang on, Mr. President. I'm trying to check it in the bundle that has been supplied here. First schedule, yeah? Sorry, Mr. President, just read it.
I can read it. Rule 4. The International Criminal Court may make a request to the Attorney General for the taking of evidence and production of documents in relation to an investigation by the prosecutor or to any proceeding before the International Criminal Court, unquote. That's Rule 4. And Rule 8 says,
Yes, go ahead.
before I go to Rule 8, because it makes reference to Rule 7, Rule 7 says, provide for forwarding the request. Upon designation of a judge under Rule 5, the AG shall forward the request received under Rule 4 together with the particulars of the intended witnesses or documents to the Chief Justice, who shall promptly transmit the request to the judge, unquote. Now, you go to Rule 8, provides 1, on receipt of the request under Rule 7, the court shall issue summons to the intended witnesses together with a summary of the issues upon which any intended witness is requested to testify on. And 2, where the request relates to the production of any document, the court shall issue summons to the person in possession of the document or who has authority over the document, requiring him or her to appear and produce the document. And here's a crucial part, 3, sub 3. The summons shall be served on the intended witness personally, and there shall be a period of 15 days between the date of service of the summons and the date any intended witness is required to appear. So we have rules intended to service what is contemplated by Article 93, 1B. My question is, if this can be, what is the material difference with saying an ICC cannot come and sit in Kenya and take this evidence itself directly?
Mr. Chairman, Mr. President, the confusion that is arising is partly caused by the fact that I have been responding to the application as framed by the prosecutor. And as I understand it, the prosecutor is not interested, and I'm not inferring. He said so in clear language. He said, I do not wish and I am not interested in a process that anticipates a Kenyan court or tribunal being involved in this process, unless I misunderstood him.
So that's
the
not
hypothecation
that is not my issue, Mr. Mugai, Mr. Attorney. The issue is not to force the prosecution, and they will respond, to go through Article 93(1)B. The question rather is, your position is that the prosecutor says, well, they are not requesting for witnesses to be compelled to appear in The Hague. They want them compelled to a certain location in Kenya so that the video examination may be done by video conferencing, or the chamber will convene in Kenya and hear the testimony of the witness in situ. My question is, and you're saying, no, that is not allowed. So
On the contrary.
as long as it's about compelling a witness at all, that's not allowed. But I'm saying here that Rule 4 in the rules, the ICA rules, and Rules 7 and 8, does suggest, does it not, that all that may be done before a Kenyan judge. And I'm saying, if that can be done before a Kenyan judge, why? What is the material difference that prevents it being done directly by the ICC sitting in Kenya, which you oppose?
Let me clarify that, because as a matter of record before this court, when an application was made in this court by the defense, I don't remember which defense, suggesting that this case could be held in Kenya, we filed a memoranda in support. So the support of the Kenya government that the ICC can sit anywhere is a matter of public record. I therefore wish to clarify that at no point have I suggested in my presentation today that the ICC cannot sit in Kenya, either physically or by video link or in any other manner.
That's not the point. The point is about compelling a witness to attend and testify.
I'm coming to that. I'm coming to that,
Mr.
Chairman,
Yes.
Mr. President. You have taken international crimes procedure for obtaining evidence rules made under the statute, and given them a meaning beyond what the statute says itself. This is subsidiary legislation of the weakest type possible, in that it has to be measured every day against the statute itself. These rules and the statute must sit together comfortably. What do the rules themselves say? They say this: these rules shall apply where the Attorney General has authorized the taking of evidence and production of evidence under Section 78 and 79 of the Act. What do 78 and 79 do? They create a general discretion on the part of the Attorney General upon a proper application. What is a proper application? It takes us back to where we have been the whole morning. Compellability. I can never imagine a situation in which I would issue a certificate for the taking of evidence without satisfying myself that the specific provisions on the taking of evidence from a witness, which are in 85, 87, 88, have been fulfilled. Nothing in these rules can confer on me a power that I don't have under the main act.
Mr. Attorney, I need to cut you short now. I've cut you. 1 second. 1 second. We've been served notice by the system, the court system, that we will be adjourning at 4:30.
Right.
And the prosecutor has a lot, I believe, on his plate to reply to. So can you wrap up now in 2 minutes?
Yes, and I'm saying this.
I'm sorry, I do apologize, Attorney General. Your Honour, I beg the Court's indulgence. I would ask that we sit till 5 o'clock, because I tried to honour the timetable that I was required to abide by, and I touched things very quickly. Indeed, there were other questions from the bench that I tried to answer in my allotted time, and I have quite a bit to say. Some issues, with the greatest respect, I have a different position from the Attorney General, and Your Honours, I would ask that that time be given to the defence. Hopefully, if we could sit till 5 o'clock, that will allow the prosecution to respond to the Attorney General, and it would give me, on behalf of Mr. Ruto, the opportunity to make what I submit are important submissions that will shed light on this issue. So, Your Honour, I would crave the indulgence of the Court. We sit by 5 o'clock, and so the necessary submissions that have to be made are put before the bench for consideration. I'm grateful.
Right. I also see Mr. you have to make some submissions as well.
Yes, Mr.
right.
President, thank you.
Let's do this. Mr. Stewart, how much time do you think you need to respond?
If you give me 10 or 15 minutes, I'll try to keep within that.
You think you can do it in 5 key points?
I think I do an injustice to what I want to tell you.
Mr. President, the other option, with your leave, the other option is that I don't know the Attorney General's commitments, but if the court was minded to allow submissions to be made on Monday,
that's what we just conferred briefly on. I think that's what we will need to do. As you know, we did not confine Mr. Attorney to time frames. The reason being we wanted to ask him all the questions we thought he can assist us with. So he need not be here on Monday. But we can resume on Monday on issue after 4:30 today and deal with any more submissions that need to be made. Mr. Kiginkatwa?
Mr. President, I was requesting that when you are allocating time, you give us some time also.
Yes, we will. As I said, we'll.
Mr. President, I might be forgiven for revising my very limited time schedule if we are going to go on Monday, but I wanted, in fairness to the Honourable Attorney General, simply to point out something that he may need to address. I didn't want to, in reply, address it when he's not here. I think that might not be right. He referred in the International Crimes Act to sections 78 and 79, quite properly in relation to the rules that you were asking him about, but under Section 80, there's very clearly a compellability feature to the provisions, and I would be unfair if I remain silent on that. I wouldn't normally have got up to interrupt the proceedings, but I did want to raise that issue. Thank you.
Thank you. So why don't we do this for all of us who are residents of the courtroom, so to speak. We can let Mr. Attorney take the rest of the day, and then on Monday we can pick up the rest of what we need to deal with. So, Section 80.
Mr. President, Your Honors, just a clarification. Initially, I had programmed myself to leave tomorrow, but of course, I would be ready to stay on if.
Senator Ruto, you can stay with us on Monday.
Very well.
If that's not too inconvenient.
All right. Thank you.
Mr. Stewart, what provision in particular are you reading?
Subsections 1 and 2 of Section 80 of the International Crimes Act provides for compellability of witnesses, and I just didn't want to leave that unsaid, because we skip beyond that to the rules, and I would expect the rules derive from that particular provision, at least insofar as a Kenyan judge is concerned, designated to take evidence.
Mr. Attorney, can you please speak to that matter?
May I, Mr. President, before I go to that issue, come to the issue you've raised in respect of Section 78 and 79, and say this. They pose absolutely no problem, because we've already discussed the two very separate cases of a witness who wishes to cooperate. Yes? If I receive a request for the taking of evidence, and a witness comes to me and says, I am very anxious and eager to give evidence, then 78 kicks in, 79 kicks in. It's not a problem.
But we're not, the matter of the witness who wishes to cooperate is controlled by Article 93 1E, is it not, of the statute?
Is it?
Yes. Article 93 1E speaks of facilitating as an assistance you may render.
That's right.
Facilitating the voluntary appearance of persons as witnesses or experts before the court.
That's right.
Now, what about 93 1B, which is a separate matter, is it not? Or is it? The taking of evidence, including testimony under oath, and the production of evidence, including expert opinions and reports necessary to the court. And then here we have Section 80 of the ICA that's talking about Section 78, the taking of evidence. And here's Section 80, talks about questions of compelling a witness to appear for a judge under Section 78.
Yes.
Yes.
First, I want to clarify this, Mr. President, sir. There is nothing in the statute that determines the procedure, and there cannot be. The purpose of the Rome Statute is not to identify how state parties will comply with the obligation. So it is incorrect to say, let us refer to 93B and we will find an answer to how evidence will be taken. We will not. We will find an obligation to facilitate the taking of the evidence. Where shall we find the procedure? In the domesticating law. And therefore, we will come to the International Crimes Act. Where shall we find that procedure? We will find it in 77 and 78. But let us read 77 and 80. Yeah, and I would plead with the court to give me time to make this argument. If you go to 77, it is very clear. The Attorney General shall give authority for the request to proceed if the Attorney General is satisfied. No any other body or authority. If the Attorney General is satisfied, not if some court or other official is satisfied. A, that the request relates to an investigation being conducted by the prosecution or any proceedings before the ICC. Let me confirm to you that I am aware there are proceedings before the ICC. B, there are reasonable grounds for believing that the evidence can be taken, or, as the case may be, the documents or other articles can be produced in Kenya. Let me break that down into two. I have to be satisfied of two things. Number one, that the evidence can be taken. Therefore, I need to be satisfied that there is a law in Kenya allowing what is said to be requested. I must be satisfied that there is such a law. And let me tell you why, Mr. President. 793B is married to 93E. It is because I have a volunteer witness that I am able to constitute a process of taking his evidence. It is not because that there is some evidence that there will be a volunteer witness. Can I make that clear? Can I repeat it again? Article 93B and 93E, are married together. the way the Attorney General will facilitate the taking of evidence under 77 and 78 is A, by being in a position to identify volunteer witnesses. Number two, let me break 77.2 further. I must also be satisfied that the evidence can be produced in Kenya. This is not about a physical thing. This is not to say that the motor vehicle is located in Kenya. No, the evidence can be produced in Kenya. It's a legal requirement. It's not an evidential requirement. I hope I am responding to that. It is a legal requirement that I must satisfy myself that the evidence can be produced in Kenya. If I am not satisfied that I'm looking at a volunteer witness, if I am not satisfied that there is a reason to do that, then I will not do it. But if I do it, that is when then Section 80 can be relevant. So that there is a process before which this would need to. But let's read the side margin on 80, Mr. President. Yes? Let's read the protection of witnesses. The applicable law without respect to compelling a person to appear before a judge under Section 78 or 79 and to give evidence or ask a question to produce document is the law specified in such. Then it goes on to say, all those notwithstanding. What is the purpose? The protection of witnesses. So my answer is a simple one. Until 77, 78, 79 kick in, 80 is an academic proposition.
That's your response to that?
That's my response.
Oh, I thought you were going to say more. All right. We've got 15 minutes to finish our time with you.
Mr. President, forgive me, Honorable Attorney General, I just don't want to be speaking on Monday about an issue that the Attorney General has not had a chance to address. We have been speaking about the possibility of a sitting in situ. If we did that, then if the trial chamber did that, the International Crimes Act has provisions that deal with that, sections 161 to 167, and we'll have a certain position on that on Monday, obviously, but I just didn't want the Attorney General to return to Nairobi without having an opportunity at least to think about those provisions before he leaves. Thank you.
Mr. Mugai, are you looking at those sections, 161 to 167?
61 of the...
161 to 167 of the ICA.
Yes.
In particular, if you looked at 162 and 163,
yes, I have no difficulty with that. I thought, Mr. President, that I had already affirmed that we as the Republic of Kenya are already on record as saying in both cases that subject to logistics and all the other issues, we have no reason to believe that the ICC cannot sit in this way. But may I draw
163 in particular? If you can look at 163, while the ICC is sitting in Kenya, it may exercise its functions and powers as provided under the Rome Statute and under the ICC rules.
Yeah, that poses no difficulty because the ICC will be sitting as if it were at The Hague.
And the provision, if you can see, it cross-references Rome Statute underneath there, Articles 4.2 and 64.
164, sir?
64.
64.
I do not know what version. One difficulty we have is the version of the ICA that I have does not have the marginal notes you are reading all along, and I do not know whether the one you are looking at would have the annotation you see underneath the...
Mr. President, with your leave, we'd be delighted to hand up an unmarked copy that has the margin notes for the bench, and perhaps it could be copied later on.
It will assist us. But in the meantime, I do not know whether the version Mr. Attorney has the annotation that appears under the provision. Not that the annotation or marginal notes would control the interpretation, but it's something of interest to see in any event. So, question is, the provision here, 163, part of the law of Kenya, clearly, so it's no longer theoretical argument. It says that while the ICC sits in Kenya, it can exercise its powers and functions as provided under the Rome Statute. And that would include what we make of the word require. This appears under Article 64(6)(b). Does it not?
I want to put it on record again that we have no difficulty whatsoever with this as a general proposition. Say to place this on record again. If the ICC was sitting in Kenya, it would be bound by Article 93E. That is to say, it would have to request me to facilitate the voluntary appearance of persons as witnesses. So we will continue with this chicken and egg, chicken and egg, chicken and egg. Will the ICC be sitting in Kenya if we have no witnesses who have volunteered to testify? And we go back to where we started in the morning. Is the Attorney General under an obligation to arrest, incarcerate, and then bring to the custody of the ICC sitting in Kenya, let us say in the UN headquarters? I have no such power. I wish I would promise I have such power. I don't.
Mr. Attorney, let's, you talk about chicken and egg. Let's address that for a minute. In the morning, when I welcomed you, we noted your impeccable credentials as a lawyer, including immediately former position of the UN Human Rights Council Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerances.
Indeed.
Right. Racism, xenophobia, related intolerances. Now, when we look at those, what is the most extreme manifestation of those social ills? Genocide, would it not be?
It probably would be, yes.
And what we're looking at here is a situation where we have a case of genocide. And you, the former UN Special Rapporteur, in capacity that encompasses that. And there's a question of whether we have to get to the bottom of it.
Indeed.
In the search for the truth.
Absolutely.
And you were saying that the witness may not be compelled to come, even though the court is sitting in Kenya, and we are looking at the provisions of 162 of the ICA, and you say chicken and egg. Is that where we left with the question of justice? Chicken and egg?
Could you permit me once more to break with tradition and put a question to you again? My heart goes out to the people who are the victims of this violence. I do not think there can be any person in the world or any group of people in the world who would be more conscious of the damage that was caused to our people and our country. Having said that, because we are a court of law, and because this is a judicial process, we must conduct it in accordance with the law. Otherwise, the temptation then to say, this has dragged on for too long, let us go into the streets and pick the people we believe we know who did this and line them up and shoot them would be a more attractive proposition. We are jurists. I do not say it flippantly or lightly that we are in a legal conundrum. I wish I had the power to unlock it. But I am an officer who has taken an oath, like you have, dear judges, to protect the law. I would break my oath if I suggested that if I were brought a warrant of arrest from here, I would go into the streets with some policemen and we pick up Mr. Walter Barasa and put him in a plane and send him to The Hague. I would not do that. I would resign my office first. Because the law does not allow me to do the things that my heart tells me. The law tells me to do what the law empowers me to do, irrespective of what my heart may feel. I would want the court, and I have said that, and I don't know whether I should repeat myself. Can the ICC sit in Nairobi? Yes. In fact, it is us who first supported that proposition, and it was rejected by you. So, to turn around and say that that can be visited on us would be very unfair. So, the ICC can sit in Kenya, the ICC can hear witnesses in Kenya, it can take evidence in Kenya, subject to the law. Subject to the law. And therefore, when I therefore want to put it on record for the sake of my learned friend, the prosecutor, that I am aware of the provisions he has referred to, and they pose no difficulty to me. What I think we ought to go back to is, in order for the ICC to come to Nairobi and sit, what would be the evidence it will be considering in its docket in that period? If it is the 7 witnesses that are alleged to have disappeared, whose names I don't know, whose identity I don't know, whose location I do not know, then we would have to have a legal procedure consistent with the treaty, consistent with the statute, and consistent with Kenya law that allows me, because that's the word. I want Mr. Henderson to hear this personally, and therefore I will repeat it. The prosecution has asked you to require us to facilitate the presence of.
You mean Mr. Stewart? Not
Sorry. I'm sorry about that. That's, he knows the other name I have used, and I apologize to him. He's a man I hold in the highest possible regard. But as I was saying, Mr. President, the prosecutor's request is that you should get us to compel the attendance of And what I have said over and over again is the mechanism for identifying these people, locating them, and then compelling them to be present is a mechanism that is problematic. I don't think that that argument has been made without some reflection on our part. It is not made flippantly. It is not made in a frivolous manner. It is made because this whole 6 hours of argument demonstrate that it is a difficult issue.
Mr. Attorney, you have 2 minutes to finish.
So let me then wrap up by saying...
And Mr. President, sorry to interrupt my learned friend, but I also don't want to raise an issue of Kenyan law in his absence, but I would ask if the learned Attorney General could look at Section 84.
That was going to be my last point.
I'm grateful.
2 minutes, because it's not in my discretion or the discretion of my
I will wrap up by
saying.
the comfort that may appear at first sight to be given by Section 80 of the ICA is indeed not a comfort, because 80 subsection 4 creates a very clear exception. And it says, notwithstanding subsection 1, a person who is required under section 78 or 79 to give evidence or produce articles is not required to give evidence or produce any document or any article that the person could not be compelled to give or produce in proceedings before the ICC. We come back to, what do you have compellability powers here at The Hague? If you don't have them, even if there was this process in Kenya, you wouldn't have them. Let me now say this. We thank you. We thank you for the opportunity. We thank you for the very engaging discussion, and I thank all my colleagues for their interventions. I want to repeat that the Kenya government remains ready, able, and willing, and desirous to assist this process, but we will do it in accordance with the law. Thank you.
Thank you. We'll leave it at that for now. On Monday, we should take up any replies and responses. We will be doing that in 1 hour, because as a witness, prosecution, I take it. Mrs. Steinberg, you have a witness on Monday, right?
We do indeed have a witness lined up for Monday, yes, Your Honor.
So we can take the first hour and wrap up what needs to be done on this discussion and compellability.
We will convey that to the witness.
Thank you. And thank you very much, everyone. We and Mr. Attorney and your colleagues wish you safe travels back. The court will adjourn.
All rise. We will then.